tell you, when we talk about attorneys who are tops in their fields and our entrepreneurs should be listening, Heather Repicky, who's a partner at Nutter, McLennan, and Fish, specializes in intellectual property. I was going to say IP, but for our listeners, intellectual property litigation. And she's going to be talking about a subject that has been widely reported. And to hear from Heather, I think that it's going to be very apropos for our group.
Well, Heather, let's get into it. What's the topic?
So today we're going to talk about patent trolls. Everyone wants to talk about them. I'm not sure people know what they are or anyone's really defined what they are.
Well, I know trolls are the little rubber dolls that have those funny little spiked hair.
Yep.
That was before spiked hair was in style.
Yep, that's a type of troll. The kind of trolls we're going to talk about today are what are otherwise known as non-practicing entities, NPEs. People also call them patent assertion entities, PAEs. Essentially, they are companies that don't make a product that is with their patent. So they have an invention, and they're going to assert it against companies who they think are infringing that patent. So one of the questions that I often get is, I just got a letter and it says to cease and desist, or we will sue you. And now what do I do? And so we have a lot of clients who have been getting patent troll letters recently. And I think that there's some good advice to really think about when you get a letter from a patent troll. And I will say that I use the troll term. I think that's a little derogatory.
Right. Right.
And I don't think that all non-practicing entities are actually deserve that term, patent trolls.
Well, I wanted to say troll because I felt like it was that commercial about fraud where the guy's going, frog? No, fraud. And I wanted to make sure people knew it was trolls like the doll.
Right.
And people can identify with this because that's how they're termed today.
Right. But I think that there are a lot of inventors, maybe even some people who are listening who say, well, I don't make a product, but I have this really great invention and I want to be compensated for it.
Right.
And I don't actually put those people in the category of patent trolls. The companies that I think are true patent trolls are those that go around, they actually purchase patents,
Right.
put them in their portfolio, and that's all they do. All they do is assert patents. They didn't invent them, they bought them, and now they're looking to get compensation for that. And oftentimes what they do is they will make a demand on other companies for something that is less than the cost of litigation. And that's sort of the big problem that companies face because patent litigation is expensive.
Right.
Very expensive. I think the most recent statistic that I saw was that for cases less than $1 million, so where less than $1 million is at issue, it will cost more than $800,000 to bring that case to trial.
Interesting.
So you're putting out a lot of money
Right. Right.
for a case that might not be worth that much. And in real patent trolls, what we see is they will demand something like $25,000. And then the company will call and say, okay, what do I do? Do I pay the $25,000 to this non-practicing entity?
Sounds like Monopoly. Or let's make a deal.
Well, yeah. So I say, well, you can pay them $25,000 or you can pay another $800,000.